Welcome to Little CPA Law Note. Hello, future attorneys. I am so glad you could join me today. We are going to master the rule on the writ of amparo, and my absolute goal here is to help you confidently understand this extraordinary remedy so you can totally ace your remedial law bar exams. I know, special proceedings can feel a little intimidating sometimes, but don't worry, we're going to break it down together, step by step, making it clear, memorable, and most importantly, bar ready. We've structured this review session into 4 procedural stages: concept and coverage, elements and burden of proof, who and where to file, and finally, the return and strict rules. Let's get right into it. Starting off with Section 1, concept and coverage. Let's understand exactly what this extraordinary writ is designed to protect, and just as importantly, what it doesn't. Let's take a look at the exact codal definition under Section 1. The writ is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation. Notice that it covers both actual violations and threatened ones. And here is a highly testable bar point. The violator can be a public official or employee, or a private individual or entity. That inclusion of private entities is absolutely crucial to remember. Now, examiners really love testing your ability to distinguish the writ of amparo from the writ of habeas corpus. In fact, this was a massive highlight in the 2009 bar exams, so keep this distinction clear. Amparo focuses on enforced disappearances and extralegal killings or threats thereof. Habeas corpus, on the other hand, focuses specifically on the unlawful deprivation of physical liberty or withholding rightful custody. You'll want to lock that difference into your memory. To further clarify its coverage, let's look at a beautiful Supreme Court ruling in Tapuz versus Judge Del Rosario. The court makes it crystal clear that this writ will absolutely not be issued to protect purely property rights. So if a bar problem gives you a scenario about a threatened house demolition or some kind of commercial dispute, amparo is not your proper remedy. It protects the highest possible rights of a person: life, liberty, and security, not property. Over in the landmark case of Secretary of National Defense versus Manalo, there's another bar-worthy doctrine you need to memorize. What happens if a victim escapes or is actually released? Does that make the petition moot? The court says no. If there is a continuing threat against the petitioner's security to life and liberty, even after they've been released from detention, the writ of amparo may still be allowed. The freedom from fear is very much an actionable right here. Moving on to Section 2, elements and burden of proof. Let's examine the specific elements of enforced disappearances and the heavy burden of proof required, which is, quite honestly, a favorite trap set by examiners. You absolutely must memorize these 4 elements of an enforced disappearance. First, there has to be an arrest, detention, abduction, or deprivation of liberty. Second, and this is the indispensable requirement, it must be carried out by or with the authorization, support, or acquiescence of the state or a political organization. Third, there must be a refusal by the state to acknowledge the deprivation of liberty or to give information on the victim's whereabouts. And fourth, the intention must be to remove the subject from the protection of the law for a prolonged period. Okay, let's test your knowledge with a real application. This perfectly illustrates how examiners will try to trick you. Consider this scenario from the 2019 bar exams. Miss A claimed her ex-boyfriend, Mr. B, was stalking her, watching her house, and causing her to legitimately fear for her life. The question simply asks, is Miss A entitled to a writ of amparo? Take a quick second to think about the elements we literally just discussed. If you answered no, excellent job. The correct suggested answer is no. Remember, amparo is proper only in cases of enforced disappearances and extralegal killings where there is direct or indirect government participation. In the case of a stalking ex-boyfriend, there's absolutely no mention of government authorization, support, or acquiescence. Without that indispensable element, this extraordinary remedy just doesn't apply. And speaking of that indispensable element, how much proof do we actually need? As brilliantly laid out in Nevia versus Pardico, the required quantum of proof for granting this petition is substantial evidence. The petitioner carries the burden of proving by substantial evidence that government participation exists. Mere allegations, rumors, or speculations that someone is missing, not enough. You need substantial evidence of state involvement. Let's jump into Section 3, who and where to file. We need to look at procedural standing. Who exactly has the legal personality to file this petition, and in what strict order? Section 2 gives us a very strict hierarchy of who may file. First up is the aggrieved party themselves. If not them, second is any member of the immediate family, so spouse, children, and parents. Third, any ascendant, descendant, or collateral relative within the fourth civil degree. And finally, fourth, any concerned citizen, organization, or institution. You have to follow this strict exclusionary order. Why? Because filing by a higher authorized party instantly suspends the right of all lower authorized parties to file a similar petition. Let's see how this translates into a bar problem. Take this scenario from the 2015 bar exams. A man named Masigasig disappeared. His wife, Mayumi, filed a petition for the Writ of Amparo. But immediately after, a non-governmental organization that Masigasig belonged to filed a separate petition. The respondents moved to dismiss the NGO's petition because of the earlier filing by the wife. So, are the respondents correct? Yes, the defense is completely correct here. The proper ruling is to dismiss the organization's petition. By applying that rigid principle of exclusionary right of action we just talked about, the prior filing by the wife, who is immediate family and falls into Tier 2, automatically suspended the right of the NGO, which falls into Tier 4. It's a simple, hierarchical rule, but it is heavily tested, so keep it in mind. Finally, we arrive at Section 4, the return and strict rules. Let's look at the respondent's mandatory return and the prohibited pleadings that are specifically designed to prevent any delay of justice. 5. I want you to burn this number into your memory. Take note of this absolutely crucial amendment to the rules. The respondent has exactly 5 working days after the service of the writ to file a verified written return. Now, it used to be 72 hours, but it was amended to 5 working days. And remember, this period cannot be extended except on highly meritorious grounds. So what happens if the respondent ignores this and fails to file the return within those 5 working days? Be extremely careful here. Under Section 12, the rule uses the word shall. If the respondent fails to file this return, the judge has a mandatory duty to proceed to hear the petition ex parte. It's not discretionary at all. If a judge fails to automatically proceed with an ex parte hearing in this exact scenario, they can actually be held liable for gross ignorance of the law. Because the Writ of Amparo is summary in nature, meaning it's meant to be fast, Section 11 outlines 12 strictly prohibited pleadings. Things like a motion to dismiss, a dilatory motion for postponement, a motion for a bill of particulars or counterclaims, they are all explicitly banned. Examiners love throwing these into questions to test your understanding of just how rapid and summary Amparo proceedings are supposed to be. Let's wrap up our review by looking at how this was applied in the 2010 bar exams. In this problem, a junior officer witnessed malversation of funds and was targeted by operatives. She filed an Amparo petition against the chief of staff. The counsel for the chief of staff immediately filed a motion to dismiss the petition, arguing that it failed to allege his client issued any order to harm her. The question asks you to rule on the counsel's motion. As a well-prepared examinee, you wouldn't even need to evaluate the merits of his argument. You would immediately strike down that motion by pointing out that it's a procedural dead end. The motion to dismiss must be denied outright because it is expressly listed as a prohibited pleading under Section 11. All lawful defenses should be raised in the verified return, not in a motion to dismiss. Easy points if you know the rule. And that covers the absolute essentials of the Writ of Amparo, from the strict requirement of state involvement to the hierarchy of filing, all the way down to that unyielding 5 working day rule. These rules are incredibly strict, but they are designed that way to protect our highest rights. As you continue your review, keep these principles fresh in your mind. You've got this, future lawyers. Thank you for watching. Please hit the subscribe button for more videos.